Okay. Let me just run down the bill order for you. HB 581, then HB 394, Delegate Gazzoni, HB 598, Delegate Boafo, HB 756, Delegate Hutchinson, HB 566, Delegate Grossman, HB 673, Delegate Embry, HB 328, Delegate Lopez, and we finish with HB 84, Delegate Kerr. So let's get to HB 581. It's an administration bill. Lindsay, remind us what the bill does.
So as introduced, the bill requires each principal department and independent unit of state government by September 1st, 2024 to create.
Is anyone else able to hear Lindsay? I'm not.
Can you hear me?
I can hear
We're
Lindsay.
not getting you.
Oh, some people are nodding, but Delegate Kerr can't hear me.
I can hear you.
Can other people hear her? I just can't.
Yes.
Yes, I think it's you.
Well, that's
You
a
might need to turn
problem.
up your volume.
So, let me.
Can you hear
leave
any
my
of
own
us, Ken?
meeting and come back in.
Guessing no.
So I'll be right back with you.
All right,
right.
I'll just sit tight for a minute.
Shall we talk about Delegate Ken Kerr?
Mhm.
Because I think of him every time I hear somebody say that they concur. I'm thinking that they're saying they concur, and that is my humor for today.
That's Ken Care.
Ah, but I think he also concurs.
Are you guys meeting or you're Ken? Are they meeting or are they?
Okay, can
And
you start
Stephanie,
again,
we can
Lindsay?
hear
I'll see.
you.
No, I can't hear you still.
Did you get some lunch yet?
Not yet. I'll probably eat.
Stephanie, you're not muted.
Make sure you get something. Take your time.
Okay,
We need a screen like the old television shows. Stay tuned. We're experiencing technical difficulties.
Okay, we should be good. Should be good now. Apologize for that, but
All right,
Yes.
can you hear me?
technical difficulties have been resolved. Yes. Okay, go ahead. Thank you.
All right, this is an administration bill. It requires each principal department and independent unit of state government by September 1st, 2024 to create a catalog containing specified information, excuse me, of each type of permit, license, or certificate that it issues and submit the catalog to the governor. By December 1st, 2024 and annually thereafter, and each principal department and independent unit must post on its website a description of the application process for each permit, license, or certificate it issues. The bill also establishes the Government Efficiency Commission, staffed by the Office of the Governor, to enhance government efficiency and economic competitiveness by monitoring efficiency in the processing of permits, licenses, and certificates, and requires the commission to submit a report of its findings and recommendations by December 1st, 2024, and annually thereafter to the Governor and General Assembly. I submitted a reprint of the bill with amendments from the administration that pushed the date for the catalog back to October 1st, 2024, or from the September 1st date, alters language of the catalog requirements, requires an interim posting of the permit information by December 1st, 2024, and then requires a completed update on or before October 1st, 2025, and each year thereafter, removes the director of the Energy Administration from the commission and adds the special secretary of GOSBA and the secretary of DeWitt, and requires 3 representatives from the business community rather than 2.
Okay, Delegate Kaiser.
Thank you, Mr. Chair. Mr. Chair or Lindsay, I had a question during the hearing on this bill, and I believe we are talking about House Bill 581, right? On the hearing on this bill, Delegate Shalega, I think, asked the question. But I don't remember the answer of where does this overlap or not overlap with Maryland Think and the things we already do? And that wasn't clear to me. If this is overlapping or double, I don't know. I was just worried how it all fit together, if someone could explain that.
Saif Rathul is here from the governor's office.
Thank you, Mr. Chair. Thank you, Delegate, for the question. So the question that was initially asked was, Maryland has, something similar to a one-stop that's supposed to look into streamlining a lot of this permitting process and such. So, one of the biggest thing that we have identified is that the one-stop portal currently is not, completely done, right? It's not a finished portal per se. There's a number of other portals that different agencies are using, such as the Business Express and a few other things. So the goal for this commission is to kind of look in through, and with the input from the Secretary of Do It and a few others, including communities who are dealing with a lot of those permits and such, to figure out how best for us to integrate all of those things together and not only just streamline it for or identify solutions to streamline that, not only just for applicants of those permits, but also lessen the workload that different agencies will have. Instead of going through 7 different applications for one permit, we can combine all of those together in one. So a lot of those conversations are taking place internally at the moment, Delegate, but this commission will allow us to have a lot more of those conversations in a transparent manner and provide input from external parties as well.
Thank you.
Thank
Thank you, and thank you for gently correcting me that it's one stop and not Maryland Think I should be asking about. All right, thank you, Mr. Chair.
You're welcome. Someone with a screen name of Stephanie, could you mute yourself, please? Anyone else have anything to ask or clarify? Delegate Kipke.
Thank you, Mr. Chairman. I'm just curious if it would make sense to have some type of a sunset on this. It seems like this should already be happening under, what Delegate Kaiser said and what Delegate Schlegel. I mean, this should already be happening. It's not, obviously, and we need to do better. But hopefully this propels the state forward into getting its act, into the right position to do this. I don't know if it's a good idea to sunset or not, but it seems like it may be redundant of what should already be happening. So I just throw that out there.
Hi, I'm sorry. I'm sorry. Whoever Stephanie is, can
Yeah.
you please?
Let me see if we can administratively mute her.
Staff can cut her, whoever created this can cut her and mute her.
Oh, yeah, we need the host to control and mute.
The host can also share this with the chair and others.
Okay, I think we've got it taken care of. Delegate Kipke, you were asking about a sunset, and Saif, do you want to respond to the sunset idea?
Yeah, thank you so much, Delegate, for that question. We debated with those as well, and something that I've addressed with a number of folks as well is that administration is having a lot of those conversations, but this goes beyond the principal departments as well. There's a number of agencies, boards, and commissions that are not within that executive body, right? So for us to really look into some of those permits and licenses and certificates, a legislation process is the best suited for that. So that was the genesis behind this. And the commission's goal largely is our technology is consistently improving, right? And we are facing different challenges now comparing to what we have faced 5 years ago or 10 years ago. So the commission's goal is to really identify the consistent challenges and problems that are facing in and coming up with creative solutions through their report process, through their coordination with external partners and some of the stakeholders and legislatures from both chambers to propose the solutions. So that's where the thought is. That's where we didn't necessarily put a sunset for this particular bill, just to identify and address those.
Okay, Delegate Kaiser.
As I was listening, thank you, Mr. Chair, and I just wanted to follow up on what Delegate Kipke said. I'm not sure I necessarily want a sunset, but I didn't feel like any part of that answer addressed whether there was a need for a sunset or not. I thought the answer talked about the program in general, and then at the end said no need for a sunset, but I didn't really follow any of the reasons for not a sunset. So I didn't know if he wanted to take another stab at that, or you just want to. I have two other colleagues with questions, but I just didn't feel like that answered the question. Thank you.
Sure, Delegate, I'll try my best and to be concise, because we're facing different challenges every year with a number of different things that are coming in through our licenses and permits, including various checks, including background checks that is needed. We didn't feel as though a sunset is required at this moment. However, that is why we have this body who can give us some of the guidance as well.
Delegate Taveras.
Thank you, Mr. Chair. Just two quick brief questions just with regards to why, if everyone else of the commission of the different departments that hire are listed, why is the Maryland Energy Administration striking out? Any reason in particular? And I did see that IT was added, so it's not a lack. I'm just curious. And with regards to each department, why is an interim description on how to apply for each permit license or certificate? Why is there an interim description as opposed to maybe at one point having like a set final?
Safe.
Delegate, I'll try my best to answer the second question. The first question is MEA does not authorize any certificates or licenses or permits. After looking through a lot of the requirements, it didn't feel as though MEA's position here is the right position. So instead of MEA's position, we have incorporated Secretary of DO-IT or their designee, as well as Special Secretary of GOSBA and or their designee as well, to provide that much needed voice from a lot of different diverse businesses and communities that they represent. I didn't necessarily follow the second question closely, Delegate, but I'll try my best to answer that. So on October 1st of this year, all of our agencies are to submit those catalogs that will include what type of permits and description and such, right? So they are already supposed to do that on October 1st. Hence, there is no requirement for us to incorporate that into the interim report, because interim report will be in December, so there is redundancy in there. However, we're open to hear additional suggestions.
Okay, we still have 7 more bills to get through, and this one looks like there's still a lot of discussion to be had. So those of you who still have questions, I would ask you to reach out to Mr. Ratul, and we will come back to this next week. I'm going to hold the bill for now. So thank you. We will move on to the next bill, HB 394, Delegate Kazoni.
This bill expands the judicial review available when there is a finding of no probable cause for the Maryland Commission on Civil Rights, by establishing that unless otherwise specified, such a finding is a final order appealable in accordance with the Administrative Procedure Act, and there are no amendments.
Any questions on this bill? Delegate Taveras, is your hand still up or a new hand? Okay.
Move the bill.
Okay, we have a motion to move the bill
Second.
and a second. All in favor of moving the bill, please say or indicate aye.
Aye.
Anyone opposed to moving the bill? Thank you. The bill moves forward with a unanimous committee recommendation, subcommittee recommendation. The next bill is HB 598, Delegate Oafo, and it's Lindsay again.
This bill generally prohibits discrimination based on an individual's military status in places of public accommodation, housing, employment, financial transactions, education, insurance, the provision of public utility services, and state personnel actions. There are no amendments on this bill. I just want to note for everyone's benefit that the sponsor had originally submitted an amendment on the bill, and he withdrew it after speaking with the Attorney General's office that it wasn't necessary. I'll also say that there were some questions at the bill hearing. And one item of testimony submitted by the Maryland Realtors questioning whether or not this would prevent entities from giving preferential treatment to veterans or people active duty military. And I spoke with the Attorney General's office. They did not feel that that would be an issue. They felt that the legislative history, which includes our discussion right now, indicates that this is prohibiting discrimination against veterans or active duty military, and it does not prevent an opportunity for preferences for them.
Thank you. Do I hear a motion on the bill? Any discussion on the bill?
Move the bill.
Second.
Okay, we have a motion, a second. All in favor of moving this bill forward to full committee, indicate by saying aye.
Aye.
Is anyone opposed to moving forward with this bill?
I wanted to hold this bill because there was some more research I wanted to do. I'm sorry. This is the military one. I just had to step out of a meeting. Can you all hear me okay?
I can.
Okay. Yeah, I had some questions that I was still waiting to hear back
Okay,
on. I'm sorry. I was going out of a meeting with the governor's people. I apologize for the delay in getting.
well, looks like you made it in time. Okay, then we will give Delegate Alston the courtesy of holding this bill for a week so she can get answers to our questions. Okay, moving on to the next bill. House Bill 756, Delegate Hutchinson, and we're still with Lindsay bills.
This bill requires the Secretary of State to furnish a state flag to drape the casket of an eligible decedent as defined under the bill. After the burial of an eligible decedent, the state flag must be claimed by and provided to the eligible decedent's next of kin or provided to a close friend or an associate if it is not claimed by the eligible decedent's next of kin. The bill specifies that only one flag may be provided for the death of an eligible decedent. The Secretary of State may not procure any state flag as required under the bill unless it is wholly produced in the United States, but that requirement can be waived if it cannot be met reasonably. I circulated an amendment from the sponsor that adds the current or a former governor of the state to the definition of eligible decedent and specifies that the Secretary of State must furnish the flag on request. So essentially, they don't have to search the obituaries to find out if they need to be providing flags, that if someone requests it, they'll provide it.
Okay, thank you. Delegate Hill.
I don't know if we have to move it I guess we have to move it first, but there was discussion that the bill does not include a process for the secretary and that there should be an amendment to that the secretary has to create a process by which they would determine who is and is not eligible. Lindsay, did you have any comment on that discussion in the committee? Or whether
Do you mean eligibility for the flag? I don't recall any concerns about the list of eligible decedents. And then there was also a question about like how would the request be
Right.
made? And it does say on request, it would be up to the Secretary of State to determine how they are willing to accept a request.
So the question was, do we have to say in the bill that the secretary shall, propagate regulations or come up with a process by which requests can be made and the veracity or whatever verified before? Or is that just known that if we tell them that they have to do this, that they'll come up with a process?
I mean, I think it's generally implied that they'll come up with the appropriate process. And then as far as their internal processes of determining whether or not it's appropriate for them to supply the flag, that would be internal to them as far as determining whether or not the person is actually an eligible decedent. I mean, that the definition is already supplied in the bill. So it's up to them to figure out how they're going to determine that that's the case.
Is
All
there
right,
anyone
thank
from
you.
the Secretary of State's office in the meeting? I don't see anyone, but I recall from the bill hearing that there was some discussion we didn't need to specify that they had to develop the process, that was understood. Delegate Taveras?
Well, thank you. Well, if, because I see the definition, but, if they do need to insert a process or establish a process or indicate that the Secretary of State shall, determine who is the eligible decedent, then that would go in page 2 after line 26 of the amended document.
Is that a suggestion for an amendment?
Yes, sir.
While we're talking about subcommittee amendments, Delegate Hill, would it give you a better level
You know,
of
I
comfort
mean,
with
if
this
Lindsay
bill?
says it's not necessary, it's not necessary. I just remember just getting a sense that as we read through the bill, it was like, you make a request for a flag and you get a flag. And and Lindsay says they already have processes or they know what they have to do. It just sounded like it was that it needed something, but I'll defer to council. She says it's not necessary, so I'm fine.
Well, we could add something. So right now, if you're looking on page 2 of the bill in lines 25 and 26, you've got a subsection B, the Secretary of State shall furnish a flag to drape the casket of an eligible decedent. With the amendment, it's on request. We could bifurcate that into, that would be paragraph 1, and then add a paragraph 2, the Secretary of State shall develop a process for requesting a flag under paragraph 1 of this subsection.
Yeah, but I think that makes it better, but I would also say in verifying,
And verifying the
Yeah.
request, something like that.
Yeah, the legitimacy of the request or something like that. Yeah,
Eligibility.
eligibility. Yeah. Thank you, Mr. Chair.
You're welcome. Just a point of procedure. If we adopt Delegate Hill's proposed amendment, do we do that before we consider Delegate Taveras?
I was considering this sort of a combination of both of their
Okay,
requests.
and Delegate Taveras, does that address your concern?
Yes.
Okay.
And if everyone is comfortable with it, we can vote conceptually, and then I'll circulate the actual language for everyone before the full committee voting.
Okay, thank you. Do we have an amendment on the conceptual amendment? I mean, do we have a motion on the conceptual amendment?
Move the conceptual amendment.
Second.
And
Okay,
just a point of order as well, we haven't actually done Delegate Hutchinson's amendment.
Right. We didn't move that amendment yet.
okay.
Right.
Do we have to move that one first, Lindsay?
No, I just am noting that that's.
Okay, we'll come back to that. All in favor of adopting the subcommittee amendment?
Aye.
Aye.
Anyone opposed?
Aye.
Okay, do we have a motion on
Aye.
the sponsor amendment?
Move
Motion.
Hutchinson's
Sponsor
amendment.
amendment.
Move Hutchinson's amendment.
Second.
Okay. All in favor of adopting Delegate Hutchinson's amendment, say aye.
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 Anyone opposed? On the bill as amended?
Move the bill. Second.
Okay, we have a motion on the bill as amended and a second. All in favor of a favorable vote on the bill as amended, indicate by saying aye. Anyone opposed? Okay, the bill gets a favorable report from subcommittee. Moving on to the next bill. HB 566, Delegate Grossman.
This bill prohibits a state entity or a political subdivision of the state from assigning Confederate name to real property, which includes streets, buildings, parks, and subdivisions owned by the state or political subdivision. If existing real property already has a Confederate name on the effective date of the bill, the state entity or political subdivision must assign a new name to the property by January 1st, 2027. The sponsor submitted amendments on this bill that were worked out with the Maryland National Capital Park and Planning Commission that alter the definition of Confederate name to include any name that commemorates or references any aspect of the states in rebellion operating as the Confederate States of America from 1861 through 1865, or any person who, in a military or civilian capacity, served voluntarily with or on behalf of that rebellion. It adds the Maryland National Capital Park and Planning Commission to the definition of political subdivision and expands the prohibition and renaming requirement to real property that is dedicated to public use, in addition to that that's actually owned by the state or a public political subdivision.
Thank you. Delegate Kaiser.
Thank you, Mr. Chair. I just skimmed through the bill real fast. Is there a process in here from this bill on when the renaming happens of how not the state part, but more so when it's local, whether the local people are invited into a situation to be part of that naming conversation? So being told you have to rename it, but are we describing the process or how a local input is needed?
That's not specified in the bill.
Is that something we also want to do, is specify that we direct them to put in a process?
I would think we need a process to say that there should be local input. Like, who's doing the renaming?
So whoever is the entity or political subdivision of the state responsible for assigning a name to the real property. So it would presumably depend on who's responsible for the naming, how the naming was done in the first place. To the extent that process is already part of the Open Meetings Act, as part of, if it was a county council or something that's responsible for doing the renaming, then those county council meetings would be open and public input, to the extent that they allow, public testimony on these things, would be incorporated. I'm trying to think if there's an example, particularly with the expansion to property that's dedicated to public use but not owned by the state or public political subdivision. I could envision that might be a less of an open process if it's not owned by the state or a political subdivision. But I also don't know of any particular examples where that would fall under that.
Delegate Johnson.
Thank you, Mr. Chair. Lindsay, there was also some discussion about instead of changing the name and signage altogether, if they rededicated it to a different person, if there was someone that had the same name, would that be done on an option at the local level or county or whatever jurisdiction that would fall in?
I think that would fall under it. The point is that if you are changing it so it is not a Confederate name, not honoring the person who participated in the rebellion, then that's no longer a Confederate name. So even if the person happens to have the same name, you're at that point honoring a different person. Similarly to if you were just creating a new road and you happen to be naming it after someone who shares the same name, it still wouldn't be a Confederate name in that case. But it would have to be, I think, made very clear that even though the name is staying the same, you're now honoring this new person.
But that
Not
would all be
new
done-
person, but this different person.
That would all be done under that general jurisdiction part of the bill? They would make.
I'm not
that
sure what you mean
decision?
by general jurisdiction.
If it was not a state road, but a county road or a municipal road or
Right, if it was a political subdivision taking the action to do it.
okay.
Or
Right.
again, whatever entity is responsible for naming the piece of property in the first place.
All right,
Because it
thank
could be a building, it could be a road, it could be a park. There's all sorts of different things caught up in the bill.
Thank you, Mr. Chair.
You're welcome. Delegate Chisholm.
Thank you, Mr. Chair. I want to make sure I understand this amendment. So it's saying, or references any aspect of the states in rebellion operating as. So we're gonna, any street with the name Carolina, South Carolina, North Carolina, Virginia, Georgia, Missouri, Alabama. And then we have states like Missouri, which was a split state. We're not going to allow anybody to use these names.
It's any aspect of the states in rebellion operating as the Confederate States of America. So I don't think it's referencing the individual states. It's their participation in the Confederate States of America.
So a soldier that was operating in, well, we had soldiers that were fighting for the Union, but were in southern states. Maryland was torn in the middle. So we're going to take away, even though Maryland was not technically part of the Confederacy, they were part of the Union. What, what about the Confederates that were fighting for the Confederacy, but were from Maryland? Their names were taken off, correct? But
If they were fighting on behalf of the states in rebellion operating as the Confederate States of America. So then, yes.
so anybody with that name of somebody that was fighting from South Carolina, if they were fighting for the Confederacy, I'm sure this is what we're trying to get at,
Hmm.
but not actually the state name. So it's actually
the-
a military member.
No, the state entity doesn't refers to state entities that would be naming or responsible for removing the name, not the actual name of a state.
I'm sorry, can someone send me, I don't have this amendment. I have the bill. I don't see an amendment in my emails. Can someone?
It was
resend
sent out. It's
I'll
amendment
forward
number
it.
2. Yeah. I think this is a slippery slope. I think you're gonna have some things renamed that should not be renamed. Because look, we have a lot of records from the Civil War, but it was 1861 to 1865. I don't know if all those records are gonna be accurate based on where a soldier might have died. Family members, we had split families. I would just hate to not honor somebody that maybe was fighting for the Union, but it historically is not recorded correctly. I mean, that's really where we're gonna get to. We're gonna get to who is gonna do the research to find out whether or not they really were fighting for the Confederacy or not. Just because they're from South Carolina or North Carolina, you know, the Civil War had a lot of split families, no matter where you were. It wasn't like we're solid in the South and everybody's fighting for the Confederacy. That wasn't true. And we're solid in Maryland because we have a lot of Confederates fighting from Maryland.
Delia, wouldn't you think there would be some type of a vetting process, an appeal process that you could trust the people involved in this to execute due diligence before they take action?
Yeah, maybe. I mean, I'd have to really, I hate to desecrate somebody's name unnecessarily.
I don't think that's
so
the intention of the
I-
bill at all.
I know
but-
that's not the intention at all, but intent and impact are two different things.
I see.
So, okay.
All right, thank you.
I'll try to do some research, but thank you, Mr. Chair.
All right, Delegate Kaiser.
Thank you, Mr. Chairman. Just thinking about what Delegate Chisholm brought up, two things. I mean, obviously, certain research would have to be done, but I think part of his example was anyone from those states, and I don't think we're saying it's that anyone from those states. It's only people who knowingly, famously, some way were engaged in the Confederacy. And the only thing I can say to the slippery slope is, Delegate Chisholm, I'll see you in 2025, and and each year thereafter. So I think there's always the chance, if that slippery slope is happening, that we can come in and make a correction. So thank you.
For the record, I know there's a Chisholm Road over in Fort Meade, but I
Well,
don't.
I'm gonna put in a bill right now to get that changed. Delegate Hill.
Thank you, Lindsay. I'm sorry. Can you explain again what the bill does without the amendment and what it does with, and it looks like there are sort of two parts to the amendment. One is adding, you know, the Maryland National Capital Park and Planning Commission, which I don't think there's a problem, but this other part is, as Delegate Chisholm discussed, this more expansive definition of what is prohibited. Can you just summarize what again, with the amendment and without the amendment?
Sure. So the bill as was originally drafted prohibited a state entity or political subdivision of the state from assigning a Confederate name to real property, including streets, buildings, parks, and subdivisions. And then if the existing real property already has a Confederate name, that it has to be renamed by January 1st, 2027. The amendments are expanding that definition of Confederate name, or clarifying it or expanding it. Again, these came from the Maryland National Capital Park and Planning Commission. So originally it said Confederate name means a name that commemorates the Confederate States of America. or any person who served voluntarily with the Confederate States of America. The amendment clarifies that the name commemorates or references any aspect of the states in rebellion operating as the Confederate States of America from 1861 through 1865. So it's sought to clarify that definition of Confederate, what the Confederate States of America were. And then it also notes that with regard to any person, that they have served in a military or civilian capacity on behalf of that rebellion. The change to the political subdivision adds Maryland National Capital Park and Planning. And then the third change from the amendment is expanding the real property to which it applies to real property dedicated to public use, in addition to that real property that would be owned or by the state or a political subdivision, because there is sometimes private property that is dedicated as a park that's open to the public, even though it's privately owned.
All right, thank you. So, Mr. Chair,
Mhm.
if they're not, if the commission's not here to address the wording, I mean, I think I understand Delegate Chisholm's concerns about or references any aspect of the states. I don't know what that means. Is it possible for, if they're not here, for us to, you know, table this and come back when they can actually be here to answer questions about this amendment?
If you'd like me to hold the bill, I'll certainly give you that courtesy.
I don't want to hold the bill. I want someone else to hold the bill. I just think it's not ready for, you know, I'm not clear that this amendment is clear.
Okay. Actually, Lindsay, I
All due
think,
respect to my good colleague, look, I'd like to hold the bill.
okay,
Thank you.
That's
You're
your
welcome,
hold,
Tracy.
then you're down one.
That's why I wanted to make sure.
okay, thank you. We'll get answers to those questions and some clarification. Delegate Johnson?
Yeah, since we're gonna hold the bill, now I wanted to make sure I understood this. The naming commission, are they the ones that are gonna do all the research on these names and make sure that that gets taken care of? The research part of it?
There's no naming commission. There were references to the federal renaming commission at the bill hearing.
Right,
The bill doesn't create any kind of commission to do this. It's up
So-
to individual entities that are responsible for naming their real property to figure out if they need to rename something.
so that's gonna be up to the local jurisdictions, the state, the individuals with properties named after something. They're all responsible for doing the research?
Yep.
Okay, all right, thank you, Mr. Chair.
You're welcome. Okay, anyone else from the subcommittee have anything to add? Delegate Shalega?
I just thought it would mention that Terry Hill owes Brian Chisholm lunch. Thanks.
Okay, you're welcome. Okay, we do have,
Second.
I have a motion and a second for Chisholm to buy Delegate Hill lunch. Okay, looks like it's unanimous, Delegate Chisholm. Looks like we do have an advocate who would like to be heard very quickly, because we still do have three more bills to go through. Rebecca Ballo?
Good morning, Delegate and members of the committee. I just wanted to say I'm with the Maryland National Capital Park and Planning Commission. I'm the Historic Preservation Supervisor. So if there were questions about, I'm not necessarily authorized to speak for the commission this morning. I was just here to observe. Our legal staff offered the clarifying definition with the text that you have in front of you in subsection B, about, you know, referencing any aspect of the states in rebellion operating. Our commission has done a lot of this research on our streets in Montgomery County and have found some examples out of the ordinary that do commemorate the Confederacy, other aspects of the Confederacy, and we offered, you know, a clarification to the definition to capture what we have found in some of our own research that we've undertaken over the last several years. But I do not want to delay anything. I just did want to let you know that we do have a representative of the MNC PPC here this morning, and we'll be happy to reconvene and answer any questions with your legal staff or with the delegates offline.
Thank you, very helpful. If those of you who have questions could You would be able to help direct them to the person who can provide the information, Rebecca?
Yes, I can provide the information, or I could direct you back to our legal staff that are working on this bill.
Okay, can you make sure that our committee has your contact info?
Yes.
Thank you. Let's go on to Delegate Embry, who's been waiting patiently. That would, Lindsay, I guess we're done with you today. We'll move on to Aaron. This is House Bill 673, Delegate Embry and Aaron.
This bill prohibits the creation of a lien on owner-occupied residential property by contract or as the result of a breach of contract for the payment of medical debt. Delegate Embry has submitted amendments that address concerns that were raised at the bill hearing. The amendments alter the definition of medical debt to mirror the definition in the Health General article. They strike the reference to excluding debt incurred due to cosmetic procedures, and provides that a court may not record a lien, whether by automatic process or on request by a party seeking to establish the lien based on an enrolled judgment for medical debt.
Thank you. Delegate Embry, anything to add to that?
If I may, the third amendment was based on information from legal aid lawyers who explained that in Baltimore City, judgments were being converted automatically into a lien on any property that a person owned in the city. So I reached out to the judiciary with this language to get their response, and it sounds like it's very, very complicated. It's a real problem. It's not just Baltimore City, it's a district court issue. But the courts say at this time, they cannot determine if a property is an owner-occupied primary property or not. I've talked very brief, I just learned this. So given that, I would actually retract the third amendment. I'd like to work on it over the interim with advocates in the judiciary, because I think it's actually a pretty big deal that, you know, there's this automatic lien placed without any scrutiny. And it's an issue because right now, obviously, the hospitals, there's no judicial review of whether the hospitals are, I'm sure they're not, but if they were, that there would be there's no backstop in the court. So not to get too in the weeds, but I think actually it makes sense to not add that amendment at this time, but I'd like to come back before this committee next year with hopefully a solution to that problem.
So you're recommending we move the first two amendments and not?
Correct. Thank you.
Okay, Delegate Hill.
I didn't understand the exclusion of cosmetic procedures. I didn't understand. And again, for some reason, I don't have amendments in my emails, but I don't understand if you're saying that medical debt due to an elective and or cosmetic procedure is allowed, or you can put a lien on a property for that, but that doesn't count as medical debt. I'm just confused about what that distinction is.
So the language we put in and we would keep in is that a medical professional has to have determined it's medically necessary. And we think that covers sort of the cosmetic procedures that are maybe aesthetic. But by including this cosmetic procedure language, it was pointed out that would include reconstructive surgery after mastectomy, or, you know, things that really are, we think, legitimate procedures. So we think, but, you know, I defer to this committee that the medically necessary language is sufficient.
But I guess what I'm asking about is what is the purpose of, there's medical debt, which means it's incurred for a medical procedure. What is the purpose of making a distinction between whether it's medically necessary or it's indicated, or why are you making a distinction at all? That's what I'm trying to understand.
And we are happy to have that withdrawn, but we thought that was important because this is not income limited. So it would be for people.
But what I'm saying, I'm sorry.
But I'm sorry. No, Delegate, if I would happily apply this to all medical debt.
Okay. I just didn't understand. I don't care if you're a billionaire and, you know, why is it okay to put your house on a lien when there are other ways to collect that money? Right. Again, it doesn't apply to second properties, doesn't apply to vacation homes. But you know, that's all I'm asking about. And it sounds like what you're saying is that as far as you're concerned, it's not necessary to make a distinction as to what kind of medical debt this applies to and what kind it doesn't. Is that a fair understanding?
That is extremely fair. Thank you.
Thank you.
Delegate Shalega?
Thank you. I'm reading in the testimony from the Hospital Association, quote, hospitals do not place liens on patients' primary residence to collect debt owed on a hospital bill. So because of that, what is your response to that, Delegate Embry?
Right. So this committee has done such amazing things already. So thank you for already making that the law. This extends to non-hospital, so private practices, dental practices, just the universe that's not hospital-based medical care. Applying the same standard.
Okay, thank you.
Delegate Chisholm?
Thank you, Mr. Chair. I think what's happening, and I think this is included in the bill, and maybe Delegate Embry could talk to it. A lot of times these hospitals, doctors' offices, medical professionals will sell the debt because they feel like it hasn't been, it's not worth their energy to get it. And I don't know if a third party then can put the lien on. I've seen all kinds of liens on, so I don't know who's putting the liens on. I see MHA is putting their hand up, so maybe they can tell me who this is really going to affect if it's not hospitals.
Begin.
Hospitals currently aren't allowed to sell debt. There's a bill to reverse that, by the way. So that was a couple of years ago. We can't sell debt. And then we also can't put liens on homes. The issue I think Delegate Embry is trying to get at is Baltimore City just automatically does it. Unbeknownst to us, they put a lien on, and we're not allowed to do that, but they're doing it. So I would like to get this cleaned up. I think it would be helpful not to have that occur.
Right. I think the genesis of the bill is really to stop liens being put on people's houses that without their knowledge or by other people other than the hospital association, and it automatically going on in Baltimore. I don't know if it goes on in other counties or not.
Working on this topic for many years now, I don't think it's going on in any other jurisdiction but Baltimore City.
Okay.
But it's an automatic thing, and it gives the wrong impression that we're putting liens on people's houses and the hospital's not doing it.
Right. Okay. Thank you.
You're welcome. Let's see, before I get to non-committee members, Delegate Hill?
Well, I am a committee member.
That's what I'm saying, before I get to
Okay.
non-committee members.
Okay, so I understand. I just want Delegate Embry to, so a couple things. Number one, I like the concept of the bill. I don't like the definition in the bill as it stands about what occurs and what doesn't occur, but that's neither here nor there. I'm not, and I appreciate her saying that she's going to come back next year to address the Baltimore City thing. I'm not clear. How is Baltimore City putting liens on for medical? Why is Baltimore City? Is it because it's the city hospital? I don't
know.
No. So according to the courts, and this is based on the Maryland rules, which obviously the courts create the rules, and it is not, according to the rules, not limited to Baltimore City, but in district, I think it's district court only. Anytime a judgment is ordered, created, that judgment is converted automatically into a lien on all property that person owes in that jurisdiction. There may be slight variation from the city and other counties, but it seems to be a statewide issue under the rules. But the reason I'm hesitant, I'm happy, if this committee wants, I'm happy to dive in and try to fix it, but that goes to changing the law around how judgments are created, which is a separate area of the law and not easy. And we would need to work with the courts on how they would identify, because right now they don't know which properties are owner occupied. And I think, so we would need to build a process in when the judgment is converted, that it's not automatic, that maybe there's an affidavit process. I'm not sure, but we have to build that into the automatic conversion of a judgment into a lien within the law, and then the rules would follow that.
Okay, but when a judgment, I'm trying to think that if a judgment is found, they know what the nature of the debt is, if it's for, non-payment child support, if it's for a car, they know what the nature is. So wouldn't it be cleaner to say that judgments cannot be converted into liens on a primary home if the debt for which the judgment is found is a medical debt?
The only problem is they don't know which is primary. I am happy to just direct the courts to figure that out, but I'm just wanted to report back that they claim that is impossible currently. That is what
To
they
know
have said
which is
to me.
primary, meaning what? People come in with X amount of debt and some of it is from medical and some of it is from, they don't come in.
You know what? I'm sorry.
No, go ahead.
If the person owns 5 properties, it could be commercial properties and residential, but let's say they own 10 residential properties, the courts don't know which one is primary currently.
Okay, so it's about what gets, but I'm asking about just, you said that the way these can get converted into liens is that someone has a debt, they're taken to court, there's a judgment that indeed they owe that debt, they're not paying it, so we're gonna put a lien. And I'm asking if it would not be cleaner to say that that action of applying a lien to property cannot be done if it's a medical debt, that there have to be other tools. And I understand you're saying they don't know what property, but a lot of the times they know there's only one property to be done. And it could be that the person is required to identify which property is claimed as their
Yeah,
primary.
it sounds like we're
Right.
getting into ECM and ENT
Well, I
territory
don't
here,
think, but
so.
anyway, I'm just wondering if that's a cleaner way to do it, to just say judgments for medical debt cannot apply to a primary.
Yes, we can say, right, cannot be a lien period. I mean, that's how it's written. It does not specify owner occupied in the amendment. So you could leave the amendment in, and the courts would just have to figure it out. I wanted to be in all, candor, let you know that the courts, believe they cannot do that at this time.
We have 5 minutes until we have to be in committee for bill hearings today. So anyone who is here for 328 or 84, I apologize. Thank you for waiting, but we are not going to get to those 2 bills today. We'll just spend maybe another minute on this one. And if we can't come to some type of resolution, we'll have to hold this one as well for next week. Delegate Chisholm?
Sorry, that was a mistake.
Okay. Delegate Alston?
I was going to try and jump in to just say that when you go to get the lien, in SDAT, it does say whether or not the property is owner occupied or not. And that's, you would be dependent on the person actually adequately reporting it to the state. So that's one place where you would find it. The other thing is when you're getting a lien and you go through that process, there's usually discovery, and those are some of the questions that a lawyer would typically ask before enacting those things. So it could be that they just have to do some due diligence before they would order the lien, but normally it's kind of automatic. So I was just going to say during the discovery process, that is a place where you can find out whether or not there's a lien,
Okay.
whether or not the property is owner occupied or if it's investment property.
All right, thank you. Look, subcommittee chair gets unlimited holds. So I guess I'm gonna have to hold this one.
Oh, I
Delegate
wanted
Kaiser?
to recommend the hold and make Delegate Hill buy me lunch too.
Okay.
I second.
All right, so we will,
Thank you all.
all right, thanks, everyone. I think we made some progress on a lot of these today. It just looks like we need a bit more time to work on them. And right now we have 3 minutes to get to committee. So that ends the work of subcommittee today. And thank everyone for coming.
Hi, Megan.
All right, we're adjourned.